Good morning, everyone, or good afternoon, depending on when you're listening to this. This is Dr. Black, your professor for our 695 class on child sexual abuse. And in this recording, in this lecture, I want to talk about the public definition of child sexual abuse. How does that definition impact reporting procedures? And we're also going to look at Tennessee's legal definition for consent and child sexual rape. Now, Finkelhor in the textbook, I think it's on page 109. He lists the 9 variables of sexual abuse, and I'll let you read through those yourself. But they are the age of the victim, the age of the perpetrator, relationship between the victim and the perpetrator, sex of the victim, sex of the perpetrator, the sexual act, consent, consequence, and sex of the respondent. What we're going to really concentrate on in this discussion is the consent. Now, for this class, of course, we're talking about consent of a child. But first, I just want to briefly talk about, consent of sexual activity, especially in the state of Tennessee, that someone cannot consent if they are under the influence, if they're disabled, if they're in some way the perpetrator is in a position of authority. So even if they say yes, they're in a position that they cannot legally consent. Also, what we're talking about here is children cannot consent, period. And even children of the same age cannot consent. By law, they cannot consent to any sexual contact with adults. Proposals to recognize otherwise should be classified as what they are, which is an attempt to advocate for revising the age of consent laws. Based on age and development, children, even adolescents, cannot fully appreciate the nature and consequences of these serious type of decisions. This is why many areas of law, including general medical care, contracts, military service, do not ordinarily allow children to consent. It's the same as in the legal system. Adolescents, as we've talked about, differ in cognitive, emotional, and psychological development compared to an adult. The legal limitations recognize that adolescents may not make optimal decisions in their best interest based on this stage of development. They may be influenced by their peers, less future-oriented, more impulsive. They might consider risk and rewards differently, and are still in the midst of developing their identity as well as their brain. Supreme Court has noted that minors are vulnerable to negative influences, pressure from family and peers, have limited control over their environment, and in many cases cannot even remove themselves from a dangerous situation. They may not be physically able to do it or mentally able to remove themselves. Now, in the United States, the age of consent is considered the minimum age at which an individual is considered legally old enough to consent to participation in sexual activity. And this can vary across states. Now, the Tennessee age of consent is 18 years old. Individuals that are aged 17 or younger in Tennessee are not legally able to consent to sexual activity, and such activity may result in the prosecution for statutory rape. I have here on this slide, and that is the definition of rape. This is out of the Tennessee laws, that rape of a child is the unlawful sexual penetration of a victim by the defendant or the defendant by a victim if the victim is more than 3 years of age but less than 13 years of age. On this slide here, you'll find, now this is the definition of statutory rape according to the Tennessee law, and there's the law 3913-506. So you can look this up if you want to read more about it. But the mitigated statutory rape is the unlawful sexual penetration of a victim by the defendant, or of the defendant by the victim when the victim is at least 15 but less than 18, and the defendant is at least 4 but not more than 5 years older than the victim. So what we're saying here is the defendant or the perpetrator, if they are younger than their victim, then they could actually not consent and not be legally responsible. Meaning that the defendant could be the one that initiated it, but they're 4 or 5 years younger than their victim, then it is not, they are no longer the defendant. So, in statutory rape is the unlawful sexual penetration of a victim by the defendant or of the defendant by the victim, when it's basically the same thing. So the victim is at least 13 years but less than 15, and the defendant is at least 4 years but less than 10 years older than the victim. The victim is at least 15 but less than 18, and the defendant is more than 5 but less than 10 years older than the victim. So these are just specific definitions on what's the difference between mitigated and statutory. Now, aggravated statutory rape is this unlawful sexual penetration of a victim by the defendant, or again of the defendant by the victim when the victim is at least 13 but less than 18, and the defendant is at least 10 years older than the victim. Now, mitigated statutory rape is a Class C felony, statutory is a Class E felony, and aggravated statutory rape is a Class D felony. Recently, the International Commission of Jurists published a report that's advocating for significant revisions to criminal law, such as decriminalizing prostitution, intentional transmission of HIV, and purchasing and possessing drugs for personal use. But most notably in this report, it calls to re-examine laws relating to consensual sexual conduct involving children under the age of majority and the people with disabilities who ordinarily cannot consent. Now, the report states that consensual sexual conduct may not be criminalized in any circumstances. Moreover, sexual conduct involving persons below the domestically prescribed minimum age of consent to sex may be consensual, in fact, if not in law. So let's talk now. Why are we learning about this type of offense? What can we do as criminal justice professionals with this knowledge? Now, state laws protect children through several mechanisms, including criminal laws against sexual assault, sexual abuse, and exploitation. Each state specifies the age of majority for sexual consent, and this generally ranges from age 16 to 18. State laws assume that sexual activities between an adult and a child below a certain age are coercive, even if both people think they are voluntary. In other words, a child under a certain age cannot legally consent. This provides an important protective mechanism and relieves children the burden of having to demonstrate the element of coercion or force normally required in sexual assault cases. Sexual assault laws criminalize sexual activity with minors because they recognize the potential for unequal, manipulative, predatory relationships. In some cases, even, adolescents consent to sexual relationship with adults who lavish them with attention and gifts. But these interactions are marked by the power imbalances, vulnerability, and distortion of trust. The sexual assault laws encompass what's commonly called statutory rape that we just saw, where the law prohibits and penalizes sexual activities based on the age of the perpetrator and the age of the victim. Now, statutory rape that we just saw, they uphold the state's duty to protect children from others. And even their own choices. Now, this is based on their vulnerability of the age of both. Each state law also classifies what actions constitute sexual abuse, and this varies again by state. Sexual abuse includes not only engaging in sexual activities with a child, but exposing those children to sexually inappropriate conduct. Sexually inappropriate content, persuading or inducing a child to participate in sexual activities, incest, or molestation. Now, the Administration for Children and Families, they classify all these actions as maltreatment for the sexual gratification or financial benefit of the perpetrator. Both categories, sexual assault and sexual abuse, can also coincide with criminal laws that are related to child exploitation and sex trafficking. Now, the FBI defines as sexual abuse of a minor for economic gain within those two categories. So how does changing the definition of consensual sexual conduct impact public views and the laws? Changing the definition of consensual sexual conduct by asserting that children may in fact consent to such sexual activities would damage, if not destroy, the state's ability to punish those most egregious criminal offenders. Now, importantly, this class of offenders sometimes defends their predatory behavior by asserting that children are sexual or they want this type of attention, and that it was mutual and acceptable. As a society, criminalizing these actions reflects public condemnation of harmful conduct and sets limits on what actions are not morally tolerable. So children are and should remain off limits to the sexual pursuit of adults. This type of proposition inverts the aim of the justice system away from protecting victims to instead sanctioning adults' predation and gratification at the expense of children's physical and psychological well-being. There are groups within our communities and within our country that are wanting to make pedophilia legal. I'll let you think about that for a minute. After publication of the report, there were several media stories that declared that it was misinformation to characterize that the report included sexual activities between adults and minors. The ICJ published a clarification asserting the report does not call for this. However, other human rights organizations have pointed out that the plain language of the report can suggest otherwise. Specifically, multiple areas of the report referenced adolescents' evolving capacity to consent and state that adolescents can consent to sexual conduct. In fact, if not in law, those words there, and assert that enforcement of criminal law should not apply when these sexual acts are consensual. In each of these sections, the report does not reference any limitations on the age of the other person engaging in this consensual act. The ICJ is a group of 60 judges and attorneys from around the world who seek to influence legislative reform and impact judicial decision-making. Although their mission calls for upholding the rule of law, this report actually outlines strategies to upend the rule of law and dismantle the whole sectors of the criminal justice system. Can you imagine if we got rid of the laws of consent and said that as long as it's consensual, that it can happen? But then again, you've got to have that legal definition of consent. Now, in the state of Tennessee, child sexual abuse is the most underreported crime and the number one public health concern that is facing children in the United States. Child sexual abuse knows no geographic, gender, economic, or racial boundaries. But there are things people in every community in Tennessee can do to help protect children. So as criminal justice professionals, we need to enlist adults. If they can help protect a child by educating themselves, by responding appropriately and taking action, and we as professionals can educate the public and parents on this. Child abuse happens in every community. We know that. 1 in 10 children will be sexually abused by the age of 18. 95% of the time, the perpetrator is someone that's known and trusted by the family. There are often no outward signs of sexual abuse, which is why it's so important to have conversations with the children in the community within our lives. So we as criminal justice professionals need to teach society how to take action. We need to hold schools, churches, sports leagues, and daycares accountable by asking them about their policies to keep children safe. We ourselves need to be a safe adult. We need to teach children to come to us for help if anyone makes them feel scared, confused, or icky. In Tennessee, there's a hotline number that you can call, and that's available on the site. But I have a granddaughter who's 11, and I talk to her about this frequently. After working with sexual offenders, my son and daughter heard it all the time. So my son, I drilled into him about not participating in dating anyone under his age, which he didn't. He had the same girl through high school, but it's just something that we have to learn and teach our children and teach the public. And the last slide here has that's one of the links for the Human Rights Report, and I will put this also in the module.